Welcome back to SCOTUS Oral Arguments and Opinions. In today's final episode, we'll discuss the June 18th, 2025 Supreme Court opinion in the case called United States v. Skrmetti, case number 23-477. This was one of the most hotly reported on and anticipated decisions of this term. As you may recall, in 2023, Tennessee enacted a law prohibiting healthcare providers from prescribing puberty blockers or hormones to minors for treating gender dysphoria or helping them identify with a gender inconsistent with their biological sex, while still allowing these same medications for treating other conditions like precocious puberty. 3 transgender minors, their parents, and a doctor challenged the law under the Equal Protection Clause, arguing it discriminated based on sex and transgender status. The Supreme Court upheld Tennessee's law in a 6-3 decision that split along ideological lines, but the conservative majority was deeply fractured on the reasoning. While all 6 conservative justices agreed Tennessee should win, they wrote 4 separate opinions disagreeing on fundamental questions about how to analyze equal protection claims involving transgender rights. This sprawling 118-page decision exposes fundamental disagreements about constitutional interpretation that will shape civil rights law for years to come. We'll dissect the reasoning behind each opinion, from the majority's narrow approach to the dissenters' sweeping constitutional vision, and explore what these divisions reveal about the court's struggle to address 21st century equality questions. Please note that this summary is read by an automated voice. The question presented in this case is whether Tennessee Senate Bill 1, SBL, which prohibits all medical treatments intended to allow a minor to identify with or live as a purported identity inconsistent with the minor's sex, or to treat purported discomfort or distress from a discordance between the minor's sex and asserted identity, violates the Equal Protection Clause of the 14th Amendment. Chief Justice Roberts delivered the opinion of the court, in which Justice Thomas, Justice Gorsuch, Justice Kavanaugh, and Justice Barrett joined, and in which Justice Alito joined as to parts A and the C tiles B. Justice Thomas filed a concurring opinion. Justice Barrett filed a concurring opinion, in which Justice Thomas joined. Justice Alito filed an opinion concurring in part and concurring in the judgment. Justice Sotomayor filed a dissenting opinion in which Justice Jackson joined in full and in which Justice Kagan joined as to parts of the Justice Kagan filed a dissenting opinion.
Chief Justice Roberts' majority opinion. In 2023, Tennessee joined the growing number of states restricting sex transition treatments for minors by enacting the prohibition on medical procedures performed on minors related to sexual identity. Senate Bill 1, SB 1. SB 1 prohibits healthcare providers from prescribing, administering, or dispensing puberty blockers or hormones to any minor for the purpose of 1, enabling the minor to identify with or live as a purported identity inconsistent with the minor's biological sex, or 2, treating purported discomfort or distress from a discordance between the minor's biological sex and asserted identity. At the same time, SB 1 permits a healthcare provider to administer puberty blockers or hormones to treat a minor's congenital defect, precocious puberty, disease, or physical injury. 3 transgender minors, their parents, and a doctor challenged SB 1 under the Equal Protection Clause of the 14th Amendment. The district court partially enjoined SB 1, finding that transgender individuals constitute a quasi-suspect class, that SB 1 discriminates on the basis of sex and transgender status, and that SB 1 was unlikely to survive intermediate scrutiny. The Sixth Circuit reversed, holding that the law did not trigger heightened scrutiny and satisfied rational basis review. This court granted certiorari to decide whether SB 1 violates the Equal Protection Clause. Held, Tennessee's law prohibiting certain medical treatments for transgender minors is not subject to heightened scrutiny under the Equal Protection Clause of the 14th Amendment and satisfies rational basis review. A. SB 1 is not subject to heightened scrutiny because it does not classify on any basis that warrant heightened review. 1. On its face, SB 1 incorporates 2 classifications, one based on age, allowing certain medical treatments for adults but not minors, and another based on medical use, permitting puberty blockers and hormones for minors to treat certain conditions, but not to treat gender dysphoria, gender identity disorder, or gender incongruence. Classifications based on age or medical use are subject to only rational basis review. The plaintiffs argue that SB 1 warrants heightened scrutiny because it relies on sex-based classifications. But neither of the above classifications turns on sex. Rather, SB1 prohibits healthcare providers from administering puberty blockers or hormones to minors for certain medical uses, regardless of a minor's sex. While SB1's prohibitions reference sex, the court has never suggested that mere reference to sex is sufficient to trigger heightened scrutiny, and such an approach would be especially inappropriate in the medical context, where some treatments and procedures are uniquely bound up in sex. The application of SB1, moreover, does not turn on sex. The law does not prohibit certain medical treatments for minors of one sex while allowing those same treatments for minors of the opposite sex. SB1 prohibits healthcare providers from administering puberty blockers or hormones to any minor to treat gender dysphoria, gender identity disorder, or gender incongruence, regardless of the minor's sex. It permits providers to administer puberty blockers and hormones to minors of any sex for other purposes. And while a state may not circumvent the Equal Protection Clause by writing in abstract terms, SB1 does not mask sex-based classifications. Finally, the court rejects the plaintiff's argument that, by design, SB1 enforces a government preference that people conform to expectations about their sex. To start, any allegations of sex stereotyping are misplaced. True, a law that classifies on the basis of sex may fail heightened scrutiny if the classifications rest on impermissible stereotypes. But where a law's classifications are neither covertly nor overtly based on sex, the law does not trigger heightened review unless it was motivated by an invidious discriminatory purpose. No such argument has been raised here, and regardless, the statutory findings on which SB1 is premised do not themselves evince sex-based stereotyping. 2. SB1 also does not classify on the basis of transgender status. The court has explained that a state does not trigger heightened constitutional scrutiny by regulating a medical procedure that only one sex can undergo, unless the regulation is a mere pretext for invidious sex discrimination. In Geduldig versus Aiello, the court held that laws targeting conditions unique to one sex do not constitute sex discrimination in the absence of a showing of invidious purpose. Similarly, exclusions of pregnancy-related conditions from disability benefits have been found not to violate the Equal Protection Clause. Thus, although only transgender individuals seek treatment for gender dysphoria, gender identity disorder, and gender incongruence, just as only biological women can become pregnant, there is a lack of identity between transgender status and the excluded diagnoses. Absent a showing that SB1's prohibitions are pretexts designed to effect invidious discrimination against transgender individuals, the law does not classify on the basis of transgender status. 3. Finally, Bostock versus Clayton County does not alter the court's analysis. In Bostock, the court held that an employer who fires an employee for being gay or transgender violates Title VII's prohibition on discharging an individual because of their sex. The court reasoned that Title VII's because of test incorporates the traditional but for causation standard, which directs courts to change one thing at a time and see if the outcome changes. Adid at 656. Applying that test, the court held that for an employer to discriminate against employees for being homosexual or transgender, the employer must intentionally discriminate against individual men and women in part because of sex. In such a case, the employer has penalized a member of one sex for a trait or action that it tolerates in members of the other. The court declines to address whether Bostock's reasoning reaches beyond the Title VII context. Unlike the employment discrimination at issue in Bostock, changing a minor's sex or transgender status does not alter the application of SB1. If a transgender boy seeks testosterone to treat gender dysphoria, SB1 prevents a healthcare provider from administering it to him. If his biological sex were changed from female to male, SB1 would still not permit him the hormones he seeks because he would lack a qualifying diagnosis. The transgender boy could receive testosterone only if he had a permissible diagnosis, like a congenital defect. And if he had such a diagnosis, he could obtain the testosterone regardless of his sex or transgender status. Under the reasoning of Bostock, neither his sex nor his transgender status is the but-for cause of his inability to obtain testosterone. B. SB1 satisfies rational basis review. Under that standard, the court will uphold a statutory classification so long as there is any reasonably conceivable state of facts that could provide a rational basis for the classification. SB 1 clearly meets that standard of review. Tennessee determined that administering puberty blockers or hormones to minors to treat gender dysphoria, gender identity disorder, or gender incongruence carries risks, including irreversible sterility, increased risk of disease and illness, and adverse psychological consequences. The legislature found that minors lack the maturity to fully understand these consequences, that many individuals have expressed regret for undergoing such treatments as minors, and that the full effects of such treatments may not yet be known. At the same time, the state noted evidence that discordance between sex and gender can be resolved through less invasive approaches. SB 1's age and diagnosis-based classifications are rationally related to these findings and the state's objective of protecting minors' health and welfare. The court also declines the plaintiff's invitation to second-guess the lines that SB 1 draws. States have wide discretion to pass legislation in areas where there is medical and scientific uncertainty. Recent developments demonstrate the open questions that exist regarding basic factual issues before medical authorities and regulatory bodies in this area, underscoring the need for legislative flexibility. C. This case carries with it the weight of fierce scientific and policy debates about the safety, efficacy, and propriety of medical treatments in an evolving field. The Equal Protection Clause does not resolve these disagreements. The court's role is not to judge the wisdom, fairness, or logic of SB 1, but only to ensure that the law does not violate equal protection guarantees. It does not. Questions regarding the law's policy are thus appropriately left to the people, their elected representatives, and the democratic process. Affirmed.
Justice Thomas's concurring opinion. A Tennessee law prevents children from receiving certain medical interventions if administered to treat gender dysphoria. The United States and private plaintiffs challenged the law on Equal Protection Clause grounds, arguing that it discriminates based on sex and fails heightened scrutiny. Today, the court correctly concludes that SB 1 does not classify on the basis of sex and thus is subject only to rational basis review. I join the court's opinion in full. I write separately to address some additional arguments made in defense of Tennessee's law. In politically contentious debates over matters shrouded in scientific uncertainty, courts should not assume that self-described experts are correct. Deference to legislatures, not experts, is particularly critical here. Many prominent medical professionals have declared a consensus around the efficacy of treating children's gender dysphoria with puberty blockers, cross-sex hormones, and surgical interventions, despite mounting evidence to the contrary. They have dismissed grave problems, undercutting the assumption that young children can consent to irreversible treatments that may deprive them of their ability to eventually produce children of their own. They have built their medical determinations on conceitedly weak evidence, and they have surreptitiously compromised their medical recommendations to achieve political ends. World Professional Association for Transgender Health, WPATH, itself recognizes that evidence supporting the efficacy of puberty blockers, cross-sex hormones, and surgical intervention for treating gender dysphoria in children is lacking. In its most recent guidelines, for example, the group notes that a key challenge in adolescent transgender care is the quality of evidence evaluating the effectiveness of medically necessary gender-affirming medical and surgical treatments over time. Nevertheless, WPATH publicly represents that gender-affirming interventions are based on decades of clinical experience and research and are safe and effective treatments. States would also have good reason to question whether WPATH has a basis for believing that children can provide informed consent to sex transition treatments. In a leaked recording of a WPATH panel, for example, an endocrinologist acknowledged the difficulty of explaining cross-sex hormones and puberty blockers to children, noting that the thing you have to remember about kids is that we're often explaining these sorts of things to people who haven't even had biology in high school yet. It's always a good theory that you talk about fertility preservation with a 14-year-old, the endocrinologist continued, but I know I'm talking to a blank wall. Over a decade ago, one of WPATH's contributors explained that WPATH aspires to be both a scientific organization and an advocacy group for the transgendered, and admitted that WPATH's standards of care is not a politically neutral document. Recent reporting has exposed that WPATH changed its medical guidance to accommodate external political pressure. Unsealed documents reveal that a senior official in the Biden administration pressed WPATH to remove age limits for adolescent surgeries from guidelines for care of transgender minors, on the theory that specific listings of ages under 18 will result in devastating legislation for trans care. Despite some internal disagreement, WPATH exceeded and removed the age minimums in its 8th edition of the Standards of Care. The court today reserves to the people, their elected representatives, and the democratic process the power to decide how best to address an area of medical uncertainty and extraordinary importance. That sovereign prerogative does not bow to major medical organizations. Experts and elites have been wrong before, and they may prove to be wrong again.
Justice Barrett's concurring opinion. Because the court concludes that Tennessee's Senate Bill 1 does not classify on the basis of transgender status, it does not resolve whether transgender status constitutes a suspect class. I write separately to explain why, in my view, it does not. As a practical necessity, most legislation classifies for one purpose or another. Laws distribute benefits that advantage particular groups, draw lines that might seem arbitrary, and set rules for specific categories of people. Such classifications do not usually render a law unconstitutional. Instead, as a general matter, laws are presumed to be constitutionally valid, and a legislative classification will be upheld so long as it bears a rational relation to some legitimate end. There are only a few exceptions to this rule: classifications based on race, sex, and alienage. Racial and ethnic classifications receive strict scrutiny. To survive a constitutional challenge, they must be narrowly tailored to serve a compelling governmental interests. Classifications based on alienage are subject to similarly close scrutiny. The Sixth Circuit held that transgender individuals do not constitute a suspect class, and it was right to do so. To begin, transgender status is not marked by the same sort of obvious, immutable, or distinguishing characteristics as race or sex. In particular, it is not defined by a trait that is definitively ascertainable at the moment of birth. The plaintiffs acknowledge that some transgender individuals detransition later in life. In other words, they begin to identify again with the gender that corresponds to their biological sex. Accordingly, transgender status does not turn on an immutable dot characteristic. Nor is the transgender population a discrete group, as our cases require. Instead, like classes we have declined to recognize as suspect, the category of transgender individuals is large, diverse, and amorphous. The World Professional Association for Transgender Health states that the term transgender can describe a huge variety of gender identities and expressions. The boundaries of the group, in other words, are not defined by an easily ascertainable characteristic that is fixed and consistent across the group. For purposes of the 14th Amendment, the relevant question is whether the group has been subject to a long-standing pattern of discrimination in the law. In other words, we ask whether the group has suffered a history of de jure discrimination. The distinction between de jure discrimination and private animus is consistent with the 14th Amendment's text and purpose. Most fundamentally, the 14th Amendment constrains state action, not private conduct.
The Equal Protection Clause does not demand heightened judicial scrutiny of laws that classify based on transgender status. Rational basis review applies, which means that courts must give legislatures flexibility to make policy in this area. Justice Alito's concurring opinion, and I concur in the judgment and join parts Skrmetti 2-B of the opinion of the court. I agree with much of the discussion in Part 2A1, which holds that Tennessee's Senate Bill 1 SB1 does not classify on the basis of sex, but I set out my own analysis of this issue in Part 1 of this opinion. I do not join Part 2, A2 of the opinion of the court, which concludes that SB1 does not classify on the basis of transgender status. There is a strong argument that SB1 does classify on that ground, but I find it unnecessary to decide that question. I would assume, for the sake of argument, that the law classifies based on transgender status, but I would nevertheless sustain the law because such a classification does not warrant heightened scrutiny. I also do not join Part 2A3 of the court's opinion because I do not believe that the reasoning employed in Bostock versus Clayton County is applicable when determining whether a law classifies based on sex for Equal Protection Clause purposes. To begin, I agree with the court that SB1 does not classify on the basis of sex within the meaning of our equal protection precedents. What those cases have always meant by sex is the status of having the genes of a male or female. That was the common understanding of the term in 1971, when the court in Reed v. Reed first held that a law that discriminated against women violated the Equal Protection Clause. My main point of disagreement with the court concerns its analysis of the plaintiff's argument that SB1 unconstitutionally discriminates on the basis of transgender status. The court holds that the law does not classify on this ground, and the court therefore applies rational basis review. I am uneasy with that analysis and would reject the plaintiff's argument for a different reason, because neither transgender status nor gender identity should be treated as a suspect or quasi-suspect class. I will not dwell on the question whether SB1 classifies on the basis of transgender status or gender identity, because in the end, I do not think that the answer to that question has any effect on the outcome of this case. But the argument that SB1 classifies on those grounds cannot easily be dismissed. I would assume, for the sake of argument, that SB1 classifies on the basis of transgender status and move on to the question whether such a classification is either suspect or quasi-suspect, and thus warrants some form of heightened scrutiny. In my view, transgender status does not qualify under our precedents as a suspect or quasi-suspect class. Transgender status is not immutable, and as a result, persons can and do move into and out of the class. Members of the class differ widely among themselves, and it is often difficult for others to determine whether a person is a member of the class. And transgender individuals have not been subjected to a history of discrimination that is comparable to past discrimination against the groups we have classified as suspect or quasi-suspect. That definition encompasses not just biological men who permanently identify as women and biological women who permanently identify as men, but also individuals who might identify with a particular gender at a particular point in time, and individuals who identify permanently or temporarily with both sexes, neither sex, or some other identity. We have previously refused to apply a higher level of scrutiny to such amorphous classes for good practical reasons. In light of all the above, I am unwilling to conclude that transgender status, like race, national origin, and sex, is entitled to a higher level of scrutiny than ordinary rational basis review. That conclusion, however, should not be taken as a denial of the discrimination that transgender people have faced, nor should it be taken as an evaluation of any specific legislative action concerning transgender persons. It simply means that transgender persons, like members of other disadvantaged groups, the poor, the aged, the disabled, etc., have not made the extraordinary showing that they are entitled to a higher level of constitutional scrutiny. Because transgender status is not a suspect or quasi-suspect class, even if Tennessee's SB1 classifies on that ground, it must be sustained so long as it bears some fair relationship to a legitimate public purpose. As the court notes, SB1 easily satisfies that standard.
Justice Sotomayor's dissenting opinion. To give meaning to our Constitution's bedrock equal protection guarantee, this court has long subjected to heightened judicial scrutiny any law that treats people differently based on sex. If a state seeks to differentiate on that basis, it must show that the sex classification serves important governmental objectives and that the discriminatory means employed are substantially related to the achievement of those objectives. Such review, known as intermediate scrutiny, allows courts to ascertain whether the state has a sound, evidence-based reason to distinguish on the basis of sex, or whether it does so in reliance on impermissible stereotypes about the sexes. Today, the court considers a Tennessee law that categorically prohibits doctors from prescribing certain medications to adolescents if and only if they will help a patient identify with or live as a purported identity inconsistent with the minor's sex. In addition to discriminating against transgender adolescents, who by definition identify with an identity inconsistent with their sex, that law conditions the availability of medications on a patient's sex. Male, but not female, adolescents can receive medicines that help them look like boys. And female, but not male, adolescents can receive medicines that help them look like girls. Tennessee's law expressly classifies on the basis of sex and transgender status, so the Constitution and settled precedent require the court to subject it to intermediate scrutiny. The majority contorts logic and precedent to say otherwise, inexplicably declaring it must uphold Tennessee's categorical ban on life-saving medical treatment so long as any reasonably conceivable state of facts might justify it. Thus, the majority subjects a law that plainly discriminates on the basis of sex to mere rational basis review. By retreating from meaningful judicial review exactly where it matters most, the court abandons transgender children and their families to political whims. In sadness, I dissent. Begin with the medical context in which Tennessee's law operates. Doctors in the United States prescribe hormones and puberty inhibitors to treat a range of medical conditions. To the contrary, access to care can be a question of life or death. Some transgender adolescents suffer from gender dysphoria, a medical condition characterized by clinically significant and persistent distress resulting from incongruence between a person's gender identity and sex identified at birth. If left untreated, gender dysphoria can lead to severe anxiety, depression, eating disorders, substance abuse, self-harm, and suicidality. Suicide, in particular, is a major concern for parents of transgender teenagers, as the lifetime prevalence of suicide attempts among transgender individuals may be as high as 40%. Tragically, studies suggest that as many as 1/3 of transgender high school students attempt suicide in any given year. When provided in appropriate cases, gender-affirming medical care can meaningfully improve the health and well-being of transgender adolescents, reducing anxiety, depression, suicidal ideation, and, for some patients, the need for more invasive surgical treatments later in life. That is why the American Academy of Pediatrics, American Medical Association, American Psychiatric Association, American Psychological Association, and American Academy of Child Adolescent Psychiatry all agree that hormones and puberty blockers are appropriate and medically necessary to treat gender dysphoria when clinically indicated. SB 1 draws exactly the same kind of sex-based line. For some treatments that help adolescents look and feel more masculine, a male minor can have the treatment and a female minor cannot. That SB 1 conditions a patient's access to treatment, even in part on her sex, is enough to trigger intermediate scrutiny. This court's equal protection precedents ask only whether a law differentiates on the basis of gender. If so, the law attracts heightened review under the Constitution's equal protection guarantee. This court's decision in Bostock versus Clayton County confirms the classification on SB 1's face. By depriving adolescents of hormones and puberty blockers only when such treatment is inconsistent with a minor's sex, the law necessarily deprives minors identified as male at birth of the same treatment it tolerates for an adolescent identified as female at birth, and vice versa. Having blithely dispensed with the notion that SB 1 classifies on the basis of sex, the majority next asserts that SB 1 does not classify on the basis of transgender status. That too is contrary to the statute's text and plainly wrong. SB 1 prohibits Tennessee physicians from offering hormones and puberty blockers to allow a minor to identify with a gender identity inconsistent with her sex. Desiring to identify with a gender identity inconsistent with sex is, of course, exactly what it means to be transgender. The two are wholly coextensive. Transgender persons, moreover, have a defining characteristic, incongruence between sex and gender identity that plainly bears no relation to the individual's ability to perform or contribute to society. As a group, the class is no more large, diverse, and amorphous than most races or ethnic groups, many of which similarly include individuals with a huge variety of identities and experiences. As evidenced by the recent rise in discriminatory state and federal policies, and the fact that transgender people are underrepresented in every branch of government, moreover, the class lacks the political power to vindicate its interests before the very legislatures and executive agents actively singling them out for discriminatory treatment. In refusing to say as much, the court today renders transgender Americans doubly vulnerable to state-sanctioned discrimination. SB 1's classifications by sex and transgender status clearly require the application of intermediate scrutiny. The majority's choice instead to subject SB 1 to rational basis review, the most cursory form of constitutional review, is not only indefensible as a matter of precedent, but also extraordinarily consequential. Instead of scrutinizing the legislature's classifications with an eye towards ferreting out unconstitutional discrimination, the majority declares it will uphold Tennessee's ban as long as there is any reasonably conceivable state of facts that could provide a rational basis for the classification. The Sixth Circuit never even asked whether the challenged sex classification in SB 1 serves important governmental objectives or is substantially related to the achievement of those objectives. All the United States requested of this court was confirmation that intermediate scrutiny applied. On remand, the courts could have taken due account of the recent developments that, according to the majority, underscore the need for legislative flexibility in this area, including a recent report from England's National Health Service on the use of puberty blockers and hormones to treat transgender minors. Yet the majority inexplicably refuses to take even the modest step of requiring Tennessee to show its work before the lower courts. This case presents an easy question: whether SB 1's ban on certain medications, applicable only if used in a manner inconsistent with sex, contains a sex classification. Because sex determines access to the covered medications, it clearly does. Yet the majority refuses to call a spade a spade. Instead, it obfuscates a sex classification that is plain on the face of this statute, all to avoid the mere possibility that a different court could strike down SB 1 or categorical healthcare bans like it. The court's willingness to do so here does irrevocable damage to the Equal Protection Clause and invites legislatures to engage in discrimination by hiding blatant sex classifications in plain sight. It also authorizes, without second thought, untold harm to transgender children and the parents and families who love them. Because there is no constitutional justification for that result, I dissent.
Justice Kagan's dissenting opinion. For all the reasons Justice Sotomayor gives, Tennessee's SB 1 warrants heightened judicial scrutiny. That means the law survives if, but only if, its sex-based classifications are substantially related to the achievement of important governmental objectives. As Justice Sotomayor notes, the point of applying that test is to smoke out invidious or otherwise unfounded discrimination. More concretely put, heightened scrutiny reveals whether a law is based on overbroad generalizations, stereotypes, or prejudices, or is instead based on legitimate state interests, such as the one here asserted in protecting minors' health. Because the court is wrong in not subjecting SB 1 to that kind of examination, I join parts 1 through 4 of Justice Sotomayor's dissent. I take no view on how SB 1 would fare under heightened scrutiny, and therefore do not join Part 5. The record evidence here is extensive, complex, and disputed, and the Court of Appeals, because it applied only rational basis review, never addressed the relevant issues. Still more, both the plaintiffs and the government asked this court not to itself apply heightened scrutiny, but only to remand that inquiry to the lower courts. So I would both start and stop at the question of what test SB 1 must satisfy. As Justice Sotomayor shows, it is heightened scrutiny. I respectfully dissent.
Those were the majority, concurring, and dissenting opinions. Given the significant fracturing, instead of discussing case implications, I wanted to delve deeper into the areas of agreement and disagreement. Let's start with the majority and concurring opinions. The fractured viewpoints highlight divisions within the conservative majority itself. Even though all 6 conservative justices agreed Tennessee should win, they disagreed significantly about how to get there. And these disagreements reveal some important tensions in conservative constitutional thinking. First, let me lay out what everyone agreed on. All the conservative justices said Tennessee's law should be upheld, that rational basis review applies instead of heightened scrutiny, and that the law easily passes that low bar. They all agree the Sixth Circuit got it right. So far, so good. But here's where it gets interesting. The justices split on some fundamental questions about how to analyze this law. The biggest disagreement was about whether Tennessee's law actually classifies people based on sex. Chief Justice Roberts, writing for the majority, said absolutely not. He argued the law classifies based on age, adults versus minors, and medical use, what conditions the treatments can address. He said the law applies the same way regardless of whether you're male or female, so there's no sex classification at all. But Justice Alito didn't buy this rationale. In his concurring opinion, he said he was uneasy with the majority's analysis. He thought there was a strong argument that the law does classify based on transgender status, even if not sex. Rather than twist himself into logical knots trying to deny the classification exists, Alito said he'd just assume it does exist and move on to ask whether that kind of classification deserves special constitutional protection. His answer, no, it doesn't. This is a classic example of different judicial philosophies. Roberts wanted to avoid the hard constitutional question entirely by saying no problematic classification exists. Alito thought that was intellectually dishonest and preferred to confront the question head-on. Justice Barrett took yet another approach. She jumped straight to the question everyone was dancing around. Should transgender people be considered a suspect class that gets special constitutional protection, like racial minorities do? Her answer was a definitive no, and she laid out a systematic analysis of why. She said transgender status isn't immutable because people can change their mind and detransition. She said the category is too broad and diverse to be considered a discrete group. And crucially, she said transgender people haven't faced the kind of systematic legal discrimination that other protected groups have historically experienced. Justice Thomas had his own agenda. He spent most of his concurrence attacking the medical organizations that support gender-affirming care, particularly something called WPATH. He accused them of letting politics corrupt their medical recommendations and argued courts should defer to elected officials, not medical experts, when the science is uncertain. Here's what's really telling about these disagreements. They show the conservative justices struggled with how to handle new constitutional questions. Do you avoid them entirely, like Roberts tried to do? Do you confront them directly, like Alito preferred? Do you systematically apply traditional legal tests like Barrett did? or do you focus on institutional questions about who should make these decisions, like Thomas did? The fact that Justice Alito felt compelled to write separately and explicitly criticize the majority's reasoning suggests real discomfort with how the court handled this case. When a justice says he's uneasy with the majority opinion he's joining, that's judicial speak for, "I think my colleagues got this wrong, but I agree with the bottom line." This kind of internal disagreement matters because it signals how the court might handle future cases involving transgender rights or other emerging constitutional questions. The justices clearly don't have a unified approach, which could lead to different outcomes depending on which methodology wins out in future cases. Now let's turn to the three liberal justices and see how fundamentally they disagreed with their conservative colleagues. The dissenting opinions, led by Justice Sotomayor and joined by Justice Jackson, with Justice Kagan writing separately, reveal a completely different vision of how this case should have been decided. The core disagreement comes down to one central question. Does Tennessee's law classify people based on sex? The majority said no. The dissenters said absolutely yes, and they couldn't believe their colleagues were pretending otherwise. Justice Sotomayor, writing the main dissent, was blunt about what she saw happening here. She accused the majority of contorting logic and precedent and refusing to call a spade a spade. In her view, the law obviously classifies based on sex because it treats male and female adolescents differently. A male adolescent can get testosterone to help him look more masculine, but a female adolescent cannot get testosterone for the same purpose. That's sex discrimination, plain and simple. Here's where Sotomayor got really pointed in her criticism. She said the majority was willing to obfuscate a sex classification that is plain on the face of this statute, all to avoid the mere possibility that a different court could strike down SB 1. In other words, she accused her colleagues of intellectual dishonesty, twisting the legal analysis to reach their preferred political outcome. The dissent also had a completely different view of the medical evidence. While Justice Thomas spent his concurrence attacking medical organizations, Justice Sotomayor emphasized the serious consequences of untreated gender dysphoria. She noted that suicide attempts among transgender high school students may be as high as 1/3 in any given year, and that major medical organizations all support gender-affirming care when clinically appropriate. But here's what's really striking about Sotomayor's approach. She wasn't necessarily saying Tennessee had to lose. She was saying Tennessee should have to justify its law under intermediate scrutiny, the heightened standard that applies to sex-based classifications. Under that standard, the state would need to show its ban serves important governmental objectives and is substantially related to achieving those objectives. The dissent argued this kind of meaningful review is exactly what the Constitution requires when the government draws lines based on sex. As Sotomayor put it, intermediate scrutiny exists to differentiate innocuous sex-based laws from discriminatory ones. Without that scrutiny, she warned, the court was inviting legislatures to engage in discrimination by hiding blatant sex classifications in plain sight. Justice Jackson, during oral argument, made a particularly compelling point that echoes through the dissent. She compared this case to Loving v. Virginia, the case that struck down bans on interracial marriage. She noted that in Loving, the state also argued courts should defer to legislators because the scientific evidence about interracial marriage was substantially in doubt. Jackson worried that the majority was making the same mistake here, letting scientific uncertainty become an excuse to avoid constitutional analysis altogether. Now, Justice Kagan's separate dissent is fascinating because it shows the internal dynamics among the liberal justices. Kagan agreed with everything Sotomayor said about the legal standard, that the law classifies based on sex and deserves heightened scrutiny. But she refused to join the part of Sotomayor's opinion that suggested how the case should come out under that standard. Why did Kagan hold back? She said the record evidence was extensive, complex, and disputed, and the lower courts had never actually applied intermediate scrutiny. She thought the court should just decide what legal test applies and send the case back down for proper analysis under that standard. Both the plaintiffs and the federal government had asked for exactly that approach. This split between Kagan and Sotomayor reveals an important strategic disagreement. Sotomayor wanted to give a full-throated defense of transgender rights and suggest the law might not survive proper scrutiny. Kagan wanted to focus narrowly on the legal standard, perhaps calculating that a more modest approach might be more persuasive, or that the court shouldn't decide substantive constitutional questions without proper lower court analysis first. The dissenters also had a completely different view of what was at stake institutionally. While the majority emphasized legislative discretion and democratic decision-making, the dissenters saw this as exactly the kind of case where courts need to step in. They argued that transgender people are precisely the kind of discrete and insular minority that the Constitution's equal protection guarantee is designed to protect. people who can't protect themselves through the normal political process. Perhaps, most powerfully, Justice Sotomayor ended her dissent on a deeply personal note. She wrote that the court's decision abandons transgender children and their families to political whims and authorizes, without second thought, untold harm to transgender children and the parents and families who love them. She concluded, "In sadness, I dissent." That's not typical judicial language. When a justice says she dissents in sadness, she's signaling that this isn't just a legal disagreement. It's a case where she believes the court has failed in its fundamental mission to protect constitutional rights. Thanks for listening to this episode. I'll be back soon with more Supreme Court analysis specifically on these opinions. If you found this valuable, please subscribe and share with anyone who wants to understand how the court really shapes our lives. Talk to you soon.